All right, let's get started, everybody. My name's Professor Ben Allery, and I'm really happy to be here hosting a webinar with you all on predicting judicial decision making using machine learning with machine learning. Our topic today is this area that a lot of practitioners really struggle with, and it's one of those gray areas where it's really hard to know how to proceed in terms of giving advice about how to characterize different gains that individuals may have in buying and selling things like corporate shares or bonds and that sort of thing. So the goal today is to talk generally about our approach to using machine learning to predict how courts will decide these sorts of gray area tax questions. And we're going to dive into a little bit about the use cases when you might use software like this. When do you turn to machine learning in tax? When does it make sense to do that? And then we're going to jump into a particular case and see how you might address it using tax foresight. If you were a practitioner and looking to provide somebody with advice, how might you best go about informing the advice that you're going to give to a client using machine learning? So this is a really exciting webinar for us to put on. We started these back in 2017, about midway through last year, and they've grown really, really popular. So we now have about 5 times as many registrants for these latest webinars than compared to the start. I know a number of you are repeat visitors, so it's great to see a number of you coming back. And for those who are new, welcome, and I hope you'll tune in future episodes. So let's get started. Just to provide a little bit of context and to situate the conversation that follows, I think it makes sense to explain where I think these kinds of research tools fit into the arc of legal research tools over time. Back in the 70s, 80s, 90s, all legal research was basically done using hard copy materials in different kinds of libraries, law libraries, tax libraries, and it was all in hard copy. If somebody else had the volume that you were looking for, you were out of luck. You basically had to wait until they returned it, were done with it, or you may never actually be able to do the research, a complete job of research that you wanted to do. That all changed with the advent of digital research tools. So by the late 90s, early 2000s, we really started to see digital research tools take over from their paper-based counterparts. Lots of advantages of digital, of course. One is that you don't have that exclusivity problem that you have with paper-based resources. Multiple people can look at the same digital document at the same time. You don't have to worry about somebody checking it out of the library and then you being left without being able to do complete research. And better finding tools, so you can actually find stuff really fast in a digital database compared to paper-based resources. At least many times that's true, especially where the materials are properly hyperlinked and indexed. You can find stuff super fast. No card catalogs for digital resources, unlike the ones that I grew up with as a grade school student, and even into university. There were physical card catalogs of topics and resources that touched on those topics. That all went away with digital. And essentially every big business now, every big law firm, every big accounting firm, every government agency that's using legal research tools has moved away from emphasizing paper-based materials. It has moved into digital-based materials. In some respect, that's an amazing change. It's happened within 20 years, this complete change from paper-based stuff to digital stuff. I think the next 20 years are going to see an equally wholesale change towards computational research tools. And that's basically what we're going to be talking about today. How does this work now? And what can we look forward to in the future as these computational tools really grow in scope and coverage and become more refined and more exciting to get things done? Basically, the computational approach moves beyond taking things from a book and moving it onto a screen and says, okay, if we've digitized this stuff, it's all in the computer. Can't we possibly use massive computing power, algorithms to figure out what it all means? So why should humans have to read from the screen all the materials that they would have in older times read from a book? why don't we synthesize the content of those materials and allow the human to really leverage the fact that all these things are digital? So you might call this different things. Predictive analytics would be one approach, machine learning, artificial intelligence. These are all words that gesture at this computational turn in legal research. And tax foresight is just one example of these kinds of computational tools. They're going to be everywhere. So the way that we approach this job in tax foresight has a similar structure to how you might think about judges deciding cases. And so in law school, when I'm teaching law students, we spend a lot of time talking about the facts of the case and how they're found by the trier of fact. And the trier of fact is typically the trial judge. So the trial judge has the benefit of listening to all the testimony of the witnesses, looking at all the documents, assessing the probity, the honesty of the witnesses, assessing the quality of the documentation, how legit they feel those documents are, and they come up with a narrative of what actually happened. So this is what we're describing on the left-hand side as the facts. So the judge finds the facts. And then in law school, we spent a lot of time focusing on, okay, so we've got these facts. This is what happened in the world. How do we make sense out of those facts legally? How do we characterize certain elements of those facts? How do we apply legal tests to those facts to produce what ultimately is of interest to litigants and to those who are operating in the shadow of the law, which is the legal outcome? And so spend a lot of time picking apart legal reasoning, analyzing different ways of thinking about legal tests, looking at conflicting lines of cases and how one might reconcile those lines of cases, and look at how judges basically treated those facts to get to the outcomes that they announce at the end of their judgments. So in tax foresight, what we do is look for the user to supply those facts. So the user is essentially performing the role of the trier of fact, providing a bunch of facts to the system. The system will elicit those facts from the user, ask all those questions, get the facts. The user makes up essentially the story, the narrative, what actually has gone on. And then we use machine learning to map those facts onto the most likely outcome that a court would have produced had a court been confronted with those same facts. If a judge had found those same facts that the user provided to the system, what is it that a judge would have likely said in those circumstances? And so our methodology allows us to have about 90% accuracy on average with respect to these different gray area questions, which is actually really, really great. I mean, on average, lawyers win half their cases when they go to court, right? Because each side predictably is only going to win half the cases. So each side is going to win half the time. Our algorithms are predicting about, with 90% accuracy, who's going to win those cases. And we do it by looking at how the courts map those facts onto particular legal outcomes. And we run our algorithms on those fact outcome pairings. And the system trains itself on how courts are actually doing this. We're not training the algorithms on the legal reasoning part. We're essentially starting with the facts and the outcomes and allowing the system to figure out what facts are driving the courts to which outcomes. And so you'll see this shortly when we get into our example. Okay, so there are different ways that you might think about the legal research path that individuals go through. In the old analog world, to find relevant cases, you'd have to go to the law library, grab physical volumes that appear to be relevant. Maybe there'd be manual indices of subsequent citations of those cases, and you go there and you can find the subsequent cases that cite to those earlier cases. A hard copy noting up process. Using digital, that became a lot faster. You could use a keyword search to find relevant cases, and then you could automatically note up the statutory section or relevant cases that you're working with, and it'll automatically present you with all the cases that cited to it. In the computational framework, you can find all the cases kind of automatically that share the same footprint as the case that you're looking at. So what you do is you choose the classifier for your legal problem. We'll do this shortly. Enter all the facts, and it's going to locate those cases that have the greatest factual similarity to the case that you've actually essentially entered into the system based on your assumptions. And we could go through this. I think it's going to become very clear when we get into actually analyzing the situation. I think the key thing for us is that we basically turn the legal research process from one where essentially those materials are in the driver's seat. So the materials are sitting there static, inert, in stacks, they're physical volumes. And the legal researcher or the tax researcher is going into those materials, heading into the stacks and trying to read them, find them, extract the information, and then the human is taking that information and applying it to the problem that they're confronted with, they're trying to solve for a client or maybe for themselves. In the computational world, the thing is different. So the skill set is really about issue identification. You have to identify the issue, then you go into the system, and the system starts eliciting the information necessary from you in order to provide a good prediction about how the situation is going to turn out. So it turns it around. And the role of the human in the process is less about becoming an information collector and synthesizer directly, and more about identifying the issues and then interacting with the tools in an intelligent way. And so this is how the computational approach is going to really change legal research. And I hope to give you a sense of that in a moment. Okay, so what are people using tax foresight to do right now? They're using it to produce the highest quality advice. So one of the things that we hear from our clients is, I can use this, it cuts down on the uncertainty that I have about the materials, it synthesizes everything. I have confidence that it's looking at all of the relevant materials, so I'm not missing anything. It's allowing me to really confidently double check my legal research, and it's faster, so it's conducting smarter, more efficient research, cutting down dramatically on the time it takes to produce a higher quality output. So it's a better output and it's produced more quickly. Very important. It allows users to quantify the risk that clients may be taking, either say in a decision about whether to engage in a voluntary disclosure. So should I voluntarily disclose this? What are the risks that if this were challenged, that I might be in trouble? And so just trying to calibrate what are the risks, what are the upsides of a voluntary disclosure, for example, or even just simple stuff like this case that we're going to talk about today involving securities trading. There would have been a moment when this taxpayer was confronted with this reassessment, went to see an accountant or a lawyer and said, so should I challenge this, or what do you think my chances are? And that individual would have gotten certain advice from that lawyer or from that accountant. And it can be very, very difficult for a lawyer and accountant to give a really confident prediction. It's very unlikely that it's a 68% chance that you'll win, for example. They'll say, well, I think we have a pretty good shot. I think it's a strong case. It's not impossible that the Crown may win, but I think we have a good shot. That can happen for sure, and that's usually the sort of advice that people get. Some accountants, some lawyers just always have a stock answer. They say, I don't know, it could go either way. It's kind of 50-50. It's really hard to say. It depends on the judge. It depends on the lawyer on the other side. It depends on how well the witnesses perform at trial. It's really hard to say which way this is going to go, which is kind of a meaningless answer, because surely in most cases, they're going to be a better answer than the other. And clients want to know what that is. And so that's often a very frustrating answer. The 50-50 answer is a frustrating answer for clients to hear. And then the other thing is it allows individuals to get an independent analysis. So it allows them to check their intuitions, double check with a completely different way of arriving at an answer. We humans are awesome at synthesizing our understanding on a limited set of inputs. So each individual lawyer or accountant will have only read a small subset of the cases on a particular issue, and still in a lot of cases be fairly well calibrated to what the courts are doing. But it's hard for them to demonstrate that that's an independent or objective view of the case law. And so that's something that tax foresight can help with. It's basically presenting someone else with the results of your analysis and say, hey, look, I ran this analysis. These are the assumptions that I made about the facts, and here's what the system's saying about the likelihood of this outcome arising. And anyone using tax foresight is going to get the same prediction if they're entering the same assumed facts. And so it's a way to basically verify and also communicate to others in a credible way about the strength of one's case. And that's important whether you're acting for the crown or whether you're acting for the taxpayer. And being able to show that it's independent, it's not biased, is a really powerful tool of persuasion. It shows that you've done your due diligence, and it's not just you saying so. It's a system that's been trained on all the case law in the area. Okay, so let's jump into our specific question for today, which relates to securities trading. So securities trading comes up all the time, and under the Act, we know that there's a contest in a lot of cases where facts could be treated either as giving rise to business income, or they could be treated as giving rise to capital gains. And the underlying facts can often support the differing characterizations by the courts, and they depend on really fine distinctions in the facts. What actually happened? Who is the taxpayer? How frequently did they trade? What were they trading? What was their intention when they traded? Why is it that they sold a particular security or a particular asset? What's actually going on here? And what's the underlying property? So you may get a different result if you have somebody buying and selling real property, that is real estate, or buying and selling securities, or buying and selling commodities or something else, or cryptocurrencies, for example. A lot of it is going to depend on very, very contextual factors, which makes it really, really difficult to provide confident advice unless you've read all the cases in the area and you're confident about your ability to synthesize what all those cases will provide in an unbiased and objective way. And that's a tall task for anyone. We humans have the neurology that we have, the psychology that we have. We engage in filtering of new information. We have confirmation biases. We suffer from motivated reasoning. If you're providing advice to a client, often you want to provide the advice that client wants to hear. And if it's a competitive market for providing advice, you might be motivated not to tell them the whole truth or to shade your advice in the way that you think your client wants to hear. And it can happen very subconsciously. And so one of the ways to protect you against this, and really high quality, sophisticated counsel have been doing this for a very long time, and sophisticated accountants have been doing this for a long time, is to take a step back and say, okay, is this legit? What would the best argument be on the other side? Am I getting this right? Am I thinking about this clearly? What are the risks? What are the exposures? And so that's second nature to a lot of seasoned practitioners. Tax Foresight can help junior and moderately well experienced practitioners get to the same level of conviction and also substantiation of their positions very, very quickly. So we're going to be looking at this distinction. It matters a lot when you're talking about buying and selling, for example, securities that are not Canadian securities. So there is this rule in the Income Tax Act that if you're buying and selling Canadian securities, you can make something called the Canadian Securities election under subsection 39(4) that will allow you to treat all of your transactions in Canadian securities, for example, as capital gains. But once you get beyond Canadian securities, that Canadian securities election doesn't apply. And there are other things that might cause that Canadian securities election not to apply to a particular taxpayer. So one is that's not actually a Canadian security. So if it's a US stock, it won't apply there. If it is the case that you're a trader or dealer in securities, then you can't make use of that election. Oftentimes, when the minister is trying to characterize a taxpayer as engaged in the business of buying and selling securities, they are saying essentially you're a day trader or you're a frequent trader in these kinds of instruments, and as a result, you need to be treated as a trader. And traders who do this professionally as business are taxed on the basis that those gains are business income to them. And so to restore parity between those who do this on a full-time basis professionally and are therefore taxed as business people earning those income, or more often maybe incorporated, so you're working for a business whose business it is to buy and sell securities, a finance company of some kind, those gains for sure are going to be taxed as business income. And to have parity between those financial companies, financial institutions, and those who are trading on their own account, if you're sophisticated and you trade a lot, you should be treated philosophically under the act in the same way as those businesses and taxes business income. On the other hand, there's a long line of cases, a long history that says, oh, corporate securities are the sorts of things that give rise to capital gains. This goes way back to a case called Irrigation Industries, decided by the Supreme Court a long, long time ago. And in Irrigation Industries, the Supreme Court split